three of you have to be sentenced for the manslaughter of Alexander Cashford at Warden Bay on the Isle of Sheppey on the evening of the 10th of August last year. T and O, you were convicted on the 16th of February. S, you pleaded guilty shortly after the trial had begun. It was an appalling incident and a senseless loss of life. The three of you decided to attack a man that none of you knew and two of you had never even met. You, T, were given his business card in an arcade 2 days earlier. That is all he did. He didn't touch you. He gave you a business card. You could have thrown it away. If you had any reason to be concerned, you could have turned to all the adults in your life who care about you. Instead, you showed it to your younger uncle, O, and the two of you went with it to see you, S. You, S, saved the phone number in your phone, and just over a minute later, a text was sent stating it was from the girl at the arcade and that she was 16. He responded, telling her that she was pretty and asking her name. A reply was sent in the false name Sienna. From then, there was an exchange of over 70 texts, culminating in an agreement to meet up in person. Alex Cashford said Sienna's age didn't put him off. He said he was 30, although in fact he was 49. Some messages may have been sent by others in your group who are not before the court, but I have no doubt you are all aware of the messages being sent, and I do not have to decide who was sending any particular message. Between you all, you suggested a meeting at night. He said he worked at nights, and he offered to meet Sienna in the afternoon. Sienna offered to send him what she called a sneaky pic. He suggested using WhatsApp to speak, but she said her mother checks her WhatsApp, so they continue to text. On the 9th of August, among the exchanges, is a text sent asking if he wants to meet at 9 p.m. on the beach, but he says he will be working. He asks if Sienna likes champagne and gets a response that she loves it. On the 10th of August, Sienna contacts Mr. Cashford. Hey, you, able to meet today? I really want to see you, and after the beach we can go back to mine. My parents won't be there. Before he can respond, another message is sent. Bring alcohol with you. I love vodka. It gets me so drunk. He maintains that he will be working. After further exchanges, they agree to meet at 7 p.m. to take a walk for an hour. His last message to her before leaving home is, how about 6:45 down by the beach wall? The three of you were together in Leysdown, passing time in the arcades. Once he arrived at Warden Bay, Alex Cashford called S's number, which he had saved under Sienna. You, T, spoke to him, and then you met him by the beach wall in Leysdown. You walked away with him for about 11 minutes, with the boys, S and O, following at a distance with another girl. On the way, S picked up a beer bottle that someone had left on the sea wall. Once you all reached a less populated area towards Warden's Bay, O and the girl moved ahead of T and Alex Cashford. T started filming, and S attacked the victim with the bottle, hitting him on the head. He runs away. Mr. Cashford fell over and got up again to run off. The bottle was thrown at him. O chased after him, but he fell over and then got up. CCTV footage filmed from some distance away shows that he is pursued. The first 999 call is 5 minutes after the first attack filmed on S's phone. Those 5 minutes of trying to escape must have been terrifying for Mr. Cashford. Eventually he fell and didn't get up again. T, you were yelling that he had hurt O, which was untrue. Witnesses saw S throwing rocks at the man on the ground, at his head and body. S then went close and kicked him in the side. Members of the public shouted at you and tried to intervene. Both S and T were shouting and swearing that the man prostrate on the ground was a paedophile. T was screaming that she was 16. Those two left, pursued by someone who'd asked for the police to be called. S and T then met up with you, O, who had stopped the pursuit some distance before. As you all walked back together to Leysdown, the recording of S hitting Alex Cashford while T screamed at him was sent to 3 of S's friends. After you were arrested, S, you told the police that the man you attacked had hit 2 minors and tried to sleep with another one. T, you repeatedly shouted that Mr. Cashford had tried to stamp on O's head, that he was a paedophile, that the police were stupid. O, you said you hadn't done anything. None of you told the truth. Alex Cashford was a loving and beloved son, brother and uncle. He lived with his parents, who are in their 70s, and who relied on his help. And he was working on a building project. His family have had to endure the publicity this case has attracted and the notoriety now attaching to their much valued family member, who has had no opportunity to defend himself. His death will be a source of sorrow for a long time. Despite the sustained efforts at CPR from members of the public and the emergency workers at the beach, Mr. Cashford died there just over an hour after he had met UT in Leysdown. The post-mortem examinations carried out by a number of experts in different fields were not able to establish a clear cause of death. He had suffered a number of rib fractures leading to internal bleeding and a collapsed lung. These may have been caused by a kick or a fall or the combination of all that had happened to him. He had previously suffered a heart attack. He had a large swollen area at the back of his head, as well as grazes, bruises, and cuts to his limbs and body. It's entirely possible that the hit to the head with the bottle, followed by the fall, the chase and the adrenaline produced throughout, led to a heart attack, which may have been contributed to by an accelerated fall at the end. And this, together with the subsequent blood loss and collapsed lung, combined in a way impossible now to determine. I have no doubt each of you was shocked to hear, as you soon did after your arrests, that he had died. But even though the medical evidence continued to be obtained, I am satisfied that before your trial began in January this year, there could not have been any doubt in the minds of any of you that but for your attack on this man, he would not have died that day in that place. The approach to determining disputed facts before reaching a basis for sentence is no different in cases involving children to adults. I heard the trial, I have listened to the submissions made by leading counsel on your behalf, and I am sure of the facts I am setting out in these sentencing remarks. I'm prepared to accept it started as a bit of mischief among a group of bored teenagers on holiday, seeing how far you could go in tricking this grown man who had behaved, according to what S was told, creepily, into texting with a girl much younger than he was. What could you get him to agree to? You may well have enjoyed laughing about it and thought you could expose him as someone behaving inappropriately towards a 16-year-old girl, a child, albeit someone capable of giving legal consent to sexual activity. So it was that you initiated contact. You were the ones who suggested meeting up. You, and I mean you collectively, because your group were all in on this, offered to send a flirtatious, sneaky pic, and so on. So far, it was relatively harmless. It didn't stay that way. As you told the jury that even that first evening, there was a plan to persuade the man to meet the girl, and when he turned up for that meeting, he was going to be attacked. This is where your joint activities became darker and moved from what might have been excusable as childish mischief to dangerous misconduct, which risked and ultimately took a man's life. As I directed the jury, however unwise it was for him, a 49-year-old man, to give you, T, his card and flatter the 16-year-old he was speaking to, engaging in the kind of messages that were exchanged, that did not give the three of you justification for doing what you did. That was to plan to do him significant physical harm, record it and publish it for your friends to see. In this country we have law, we have police, we have a justice system. Everyone is equal under the law. Everyone has the right to expect to be treated fairly and allowed to give their side. No one can be punished without law. I am sure that you knew and know now that if you had a complaint, there is a right way to go about making it. None of you chose that right way. And on everything I've read about you, I'm sure that each of you was mature enough to understand that what you were doing was completely wrong and unlawful. This was not a spontaneous incident of violence. It wasn't a group acting together by instinct, egged on by each other. None of you can sensibly claim to have been led on, manipulated, or to have fallen into bad behaviour without thought. This is simply not that kind of case. You all planned to trap and harm this man over a few days and as a group. The sentence I impose must be proportionate to the seriousness of the offence. Manslaughter is a serious offence. In your case, the foundation for manslaughter rather than murder was only that your intention was not to cause really serious harm or death, but less than really serious harm. As there is no offence-specific guideline for children, I have had regard as a preliminary consideration to the adult guideline for unlawful act manslaughter. S. You are the person who took the lead in the violence and you bear the greatest responsibility. It is agreed by your lawyers that had you been an adult, the starting point for a custodial sentence would be 12 years, as this is a high responsibility case. I do not apply the guideline that indicates such a sentence because it does not apply to children. I reach a starting point which is 2/3 of that, 8 years. This has to be raised a little because you used a weapon. This was a planned attack intended to cause serious but not really serious harm. You were in a group with others and you intended to humiliate the victim by publicly shaming him, by recording the attack and sending it around, identifying him as a paedophile. That was all part of the plan. Indeed, you told the jury that all three of you planned this on the first day, and the intention was that you and O would hit him, but it would be in the dark so you wouldn't be caught. T wouldn't join in the violence because she is a girl. As you were following him along the beach wall, you gave your bag to the other girl who was with O. You told the jury that was because it would have restricted your movement in a fight. T already had your phone. O and you discussed how you were going to hit him. You were going to attack first and then O would run up and hit him too. This was going to happen in an area where there were not many people, and when T stopped walking, that was a signal to attack. It was going to be an attack with fists, but when you saw the bottle, you decided to use it. What was not part of the plan was to kill him. But the law requires you to take your victim as you find him. He turned out to be somebody who'd had a heart attack in the past. The jury did not convict you of murder, and so I do not sentence you on the basis that you caused the rib fractures he suffered with a kick involving the use of severe force. However, you did use the bottle to his head. You did pursue him even after T had taken the video of you doing that while she was screaming that he was a paedophile. You pursued him and threw rocks at him, which I'm sure did hit him, and then you kicked him to his side using moderate force while he was lying on the ground. All these things shocked those who saw it. The persistence of your attack and the posting of the video T had taken to 3 of your friends immediately afterwards make your role more serious than that of T and O, even though they had agreed to the plan to attack Mr. Cashford? There is some mitigation in your neurodevelopmental conditions which reduce your responsibility, and I do take account of your history. I am sure you are genuinely remorseful. Carefully balancing the factors that make the case more serious than the term of 8 years and those that provide mitigation, I return to 8 years. You pleaded guilty to manslaughter 2 days after the trial had started. You had never indicated an intention to plead guilty to manslaughter before that, although the account set out in your defence statement was consistent with such a plea. The court must take into account when an indication to plead guilty is given. Section 5 of the Children Guideline is relevant. It closely follows the Adult Guideline. Taking all the relevant features into account, I will reduce the sentence by 1 year to reflect that guilty plea. In your case, S, the sentence is 7 years custody. T, your role was central. You were the one who shared the business card Alex Cashford gave you. And it was only because you wanted to pursue him that any of this happened. You were the one who went to meet him. You walked away from the more populated area with him, and it was on your signal that the attack by S and O began. Anyone listening to your screaming encouragement to S to get him on the video you recorded on S's phone would be horrified, as your parents plainly were. In your case, the starting point is also 8 years custody. You saw S use the bottle to Mr. Cashford's head, and you continued to pursue the victim with S. You were present when S threw the rocks and kicked Mr. Cashford while he was on the ground. You claimed falsely to the police when you were arrested that he had hurt your uncle O. You did not strike the man on the ground, although you did encourage S to do so by your shouting. You do not have the benefit of a guilty plea. Overall, the term is 7 years custody. O, you are the youngest. You agreed with S and T that the man who you had seen talking to T in the arcade would be attacked, and the attack filmed. After S hit Alex Cashford with the bottle, you pursued him. I am sure that you only stopped because you also fell over and got hurt, and so there is no basis for reducing your responsibility for the attack, albeit you did not stay for the totality of it. You lied to the police when you said he had hit you. Because of your age, the starting point in your case will be 6 years custody. I make a further reduction because of the proportionately greater impact on a younger child of a period in custody. The term in your case is 5 years. You will each serve 1/2 and then be released on licence. The time you've already spent will count. I'm sure that you'll be given the date of your release very soon after today. And I want to make one further observation which I hope you will remember. You are all young, and you will still be young when you rejoin society. You did a terrible thing, and you are each paying a price for it. But there is great potential for each of you to live a good and fulfilling life when you are released. It's up to you to choose how you will live. Can you please leave court now? Thank you.